नहीं होगा,
ओरिएंटेशन इज लॉ।
बात करो।
हेलो,
नहीं होगा चेंज, नहीं होगा चेंज, ऐसे ही लगा।
ऐसे लगाते हैं ना
इसको ऐसे कर, इसको खोल सीधा।
सर, इसको सीधा खोलो इसको।
उसको बंद कर दो।
दूसरी आ रही है, दूसरी आ रही है।
हाँ,
इसको बढ़ाओ।
रुकिए सर, रुकिए। हो गया, पीछे करना।
चेंज करो, ठीक है सर। कोई लिंक भेज दिया?
नहीं सर, ये नहीं भेजा है।
लिंक भेज, लिंक भेज।
हो गया सर, देखिए लिंक गया होगा।
इसलिए होगा ना,
क्या कुछ लगाना है?
और देख रहे हैं कि उसमें वो इधर
कोई बात नहीं, लिंक गया ना। अभिनव
ज़्यादा टेंशन नहीं लेना है।
इसको ऐसा करके
रुकना 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 है।
ए
गया सर, अभी देखिए तो।
अभिनव सर,
आपने ऐसे दिखेगा, नीचे जो है वो ऐसे दिखना चाहिए।
अरे भाई, हमको इसे घुमाने के लिए कितना इसे करना होगा पूरा, यहाँ से
ऐसे करके
ऐसे
आपको।
देख।
क्यों ऐसे नहीं हो रहा?
नहीं ना, ये इसे ऑड हो गया ना।
रुकिए 1 मिनट।
ये नहीं घूमता है क्या?
1 मिनट, आप फ़ोन को ऐसे पकड़िए तो मैं इसका सेटिंग देखते हैं।
तब तो
ये ऐसे ही ऐसे रहेगा, तब ऐसे से घूमेगा।
वही ना,
ऐसे रहेगा तो नहीं घूमेगा ना।
हम यहाँ से घुमा देंगे ना,
यहाँ से
सर, ऐसे घुमा देंगे।
ऐसे इसको लॉक कर दीजिए। भाई आराम से फोन पानी हो गया।
हट, हो गया, हो गया। कोई गिर रहा है, उसको सेट कर पूरा टाइट।
ऐसे रखना है।
हाँ,
ऐसे रखो।
एक बार अभिनव सर से
इतना
बात
तेज नहीं ना।
आराम से। तो लिंक भेजे हैं, लिंक भेजे।
अभिनव सर को फोन करके पूछो ना, चल रहा है कि नहीं।
चल रहा है, देखिए ना
सर, देखिए।
अभिनव सर को पूछिए, अभिनव सर को फोन करके पूछो नीचे ऑन हुआ कि नहीं।
चल रहा है सर।
मैं ये कह रहा हूँ अभिनव सर को पूछो।
हाँ हाँ, पूछ रहे हैं सर, पूछ।
कर रहे भैया,
माइक लाते तुम्हारा सारा दवा।
बिजी आ रहा है।
फिर से बना रहा है।
हो गया, हो गया।
नहीं सर, वो नीचे क्या हो रहा है ना सर, फोन में तो ठीक चल रहा है, नीचे क्या हो रहा है कि सीधा चल रहा है। तो फोन को सीधा रखेंगे तो वो ऐसे चलेगा।
सर पूछिए ना अभिनव सर से।
हाँ सर,
फोन पे तो अच्छा आ रहा है। नहीं, नीचे नहीं चल रहा है ना। तुम लोग जाओगी एक बार नीचे।
यहाँ पे हम लोग को 2-3 लोग चाहिए, क्योंकि भाई एक ही लोग यही नहीं रहेंगे भैया। देखिए, आपको 1 आध घंटा तक खड़ा रहना पड़ेगा, है ना।
हम ना यहाँ पे
नहीं आ रहा, 1 मिनट, पूरा स्क्रीन नहीं आ रहा।
पूरा स्क्रीन नहीं आ रहा है।
तू नीचे जाएगा।
नहीं, हम समझ गए यहाँ से, जो नीचे हो रहा है हम समझ गए यहाँ से।
आगे वहाँ चलिए।
फुल स्क्रीन नहीं आ रहा है।
फुल नहीं आएगा क्योंकि इसका फोन लॉक्ड है, ऐसे ही चलेगा।
वहाँ पे अच्छा, हाँ हाँ, ऐसे ना सर, ठीक है,
ऐसे ही चलेगा,
वैसे ही
फुल नहीं
चलेगा।
आएगा।
अरे एक सब्सक्राइबर नहीं ना।
चलो
कौन है रेगुलेटर? कौन? ये 2 लोग यहाँ पे, तुम लोग जो चाहिए वही। हाँ, तुम लोग
यहाँ पे रहो, सुनो
सर, यहाँ पे ट्रेड करने के लिए अब 1 घंटा तक चाहिए।
2 को यहाँ पे खड़ा रहो।
बाकी कोई इशू नहीं है।
एक आदमी बस और रहो यहाँ,
एक
दो नहीं, 3 नहीं,
एक रहो कोई। कौन
एक
सा?
रहो, 4 5 नीचे उन्होंने। तो राहुल तुम खुद रहो यहाँ पे।
राहुल वहाँ कोर्ट मास्टर
राहुल तो अपनी जगह पहुँच गया, तो अपनी जगह जा। दोनों एक बैठ जाओ, अगर हुआ तो हम चेंज करेंगे। एक बैठ जाओ, एक बैठ जाओ, एक कोई बैठ जाओ, यहाँ पे आ जाओ।
यहाँ पे सर।
एक यहाँ खड़े हो जाओ। बाकी सब बाहर, बाकी सब बाहर, सब बाहर, सब बाहर।
Rebel code is now in session. Please keep your phone on silent mode or on switch off mode, and also maintain the decorum of the court. With the due permission of the bench, we may proceed.
Good afternoon, Your Lordship, and everyone present here. Welcome to the final of the M.M. Banarjee Memorial National Football Competition 2025. I will provide the brief details about the teams and the procedure for this session. In the case of Vijay Kumar and others versus E-Commerce Corporation Private Limited, Team PCCLC 106P will be representing as a petitioner, and Team PCCLC 121R will be representing as a respondent. He is the timer and will be managing the team time for the session. Each team has been allotted 30 minutes for their oral submission, and both the teams have 6 minutes collectively for rebuttal and sub-rebuttal. With your due permission, Your Lordship, shall we proceed further? Your Lordship grant the permission to call the petitioner. Petitioner, now you may proceed.
The Council requests permission to approach the dais. The Lordship, am I audible? The Council requests permission to address the bench collectively as the bench and individually as the Lordships. Match up bench. Greetings to the Honorable Bench. Present before you is Speaker number 1 on behalf of the appellants in the present matter of Mr. Vijay Kumar and others versus E-Commerce Corporation Private Limited. Your Lordships, over the course of the next 15 minutes, the present Council shall be delivering arguments on issues number 1, 2, and 3. With the leave of this Honorable Bench, can I please brief you with the most pertinent facts present to the pertinent matter? Much obliged, Your Lordships. Your Lordships, the present matter has been brought to the jurisdiction of this Honorable Bench under Articles 133 and 134A of the Indian Constitution. Your Lordships, the present matter has been raised in an appeal before this Honorable Bench. The appellants are consumers or customers of the respondent, which runs an e-commerce platform. The appellants are assailing the validity of the standard form of e-contract that was executed between the respondents and the appellants. In particular, clause 4A of this particular contract, which unreasonably bans all refunds, returns, and exchange on all defective products issued to the appellants. Your Lordships, with the permission of this Honorable Bench, the Council seeks to place before this Honorable Bench a set of annexures labelled Annexure A, C, D, and E, which the Council would be requesting the Honorable Bench to peruse from time to time. Much obliged, Your Lordships. Mr. Court Counsel. Your Lordships, it is humbly pled before you that in the present matter, when a marketplace becomes a maze, the consumer becomes its victim. And today, this Council is representing the voices of many such consumers who have been denied the most basic consumer right, that of returning and getting a refund for an inherently defective product. Your Lordships, in this pretext, the Council seeks permission from this bench to firstly deliver arguments on issue number 1. Much obliged, Your Lordships. Your Lordships, issue number 1 pertains to the question of the validity of the standard form of e-contract, which was executed between the respondents and the appellants in the present matter, to which we, as consumers, the appellants in the present matter, humbly believe that this particular contract is completely invalid and falls short of all the requirements present in Section 10 of the Indian Contract Act. Your Lordships, under this particular argument, the submission, the Council shall be demonstrating 2 arguments. Firstly, Your Lordships, in the present matter, this contract is invalid because it fundamentally lacks consent on part of the appellants, which are the consumers in the particular matter. And secondly, Your Lordships, this particular contract is also invalid because it derogates, it is patently illegal and is a derogation of several consumer protection laws existing within the country. With the Honorable Bench's permission, the Council will be first highlighting the first prong of their argument, that in the present matter, there is no consent on part of the consumers, the appellants in the present matter. Your Lordships, Section 10 of the Indian Contract Act enlists the element of consent as one of the most quintessential requirements of a valid contract. Your Lordship, Section 13 of the Indian Contract Act elaborates on this element of consent as consensus ad idem, which mandates that two parties of a particular contract, of a valid contract, they need to agree to the same thing in the same sense. Your Lordships, can the Council please refer you to open the Moot proposition and refer to paragraph page number 8 of the Moot proposition, and please refer to clause 4A of the contract in question. Your Lordships, page number 8, clause 4A. Whenever your Lordships are ready. Your Lordships, in this particular clause, it is clearly written that all electronic products purchased using the express purchase feature are non-returnable. It further goes on to say, by completing the purchase, the consumers expressly waive their right to return these items to the respondent in question. Your Lordship, this particular clause is so patently unreasonable that no party, no consumer in their right minds would ever give their assent to a clause like this. Your Lordship, this particular contract is a standard form of a contract. In standard forms of contract, through the established jurisprudence of this honorable bench, it has been established that the entirety of the contract and all the terms and conditions it contains must be brought to the full and accurate disclosure to the consumers, especially your Lordships, where it contains a restrictive clause, like clause 4A in question, which explicitly asks the consumers to waive their right. Your Lordship, this takes the Council to beg the Honourable Court to please refer to the compendium, which is labelled as annexure number A. Your Lordship, through this, the Council wishes to highlight case number 36. Page number 49, Your Lordships. Your Lordships will find the judgment and the relevant paragraph from Prakash Road Lines versus HMP Berry. Are Your Lordships with me? Yes. Much obliged, Your Lordships. Your Lordships, to the means of this particular paragraph, the Council only wishes to highlight that consumers often sign standard forms of contract without going through them in their entirety. Your Lordships, if all such clauses of a standard form of contract are enforced against consumers, then the court will also be enforcing against them such clauses that they did not originally give their assent to. Your Lordships, the very paragraph further goes on to state that the Supreme Court itself cautions sellers, in fact, that in cases of take it or leave it contracts, standard forms of contract, all terms are to be brought to the notice of the consumer's concern, which leads the Council to the very second prong of their argument under this issue, that the contract in question, clause 4A in question, is patently illegal and is a derogation of several consumer protection laws. However, Your Lordships, to substantiate on this point, the Council begs permission to go into issue number 2. With the leave of this Honourable Bench.
Just before.
Indeed. Indeed, Your Lordship.
Number 2.
Indeed.
You are referring to the argument.
Absolutely, Your Lordship.
Whether the question of jurisdiction and alternative remedy can be raised or whether it was raised.
Your Lordships, in the present matter, the appellants in question, this present matter is actually a class action suit, which was originally filed in the Mumbai High Court. The High Court, after realizing the significant importance of this particular matter, referred it to the Supreme Court.
Directly it was filed before the High Court.
In a class action suit, Your Lordships, yes. And then it was referred to this Honourable Bench. And the Council is litigating this particular matter on Article number 133 and 134A of the Indian Constitution. Does that answer Your Lordship's question? Much obliged. Does the council have permission to proceed to issue? Much obliged, Your Lordship. Much obliged. Your Lordship.
What's the name?
Aditi Verma, Your Lordship.
Aditi Verma.
Yes, sir.
Okay, Aditi, proceed.
Much obliged, Your Lordship. Your Lordship, on issue number 2, the council's humble submission is simply this, that in the present matter, the respondents have used unfair trade practices in the course of their business, and the council shall be arguing this on 2 prongs, Your Lordship. The first is that this particular clause in question, clause 4A that we are talking about, is directly in contravention of the Consumer Protection Act of 2019. And secondly, that in the present matter, the respondents in their e-commerce platform on their website have used dark patterns, which are illegal to use. Your Lordship, on the very first submission that this particular clause is directly in derogation of the Consumer Protection Act, the Council begs your attention on the fact that unfair trade practices have been defined by subsection 47 of section 2 of the Consumer Protection Act. Your Lordship, firstly, clause 1 of this particular provision in subclause B clearly states that whenever a seller falsely represents to its consumers that its product is of a certain standard or of a certain quality, and when the product itself is below or is substandard and does not adhere to the promised quality, then that entire act is a unfair trade practice. In the present matter, through a bare perusal of paragraphs 11, 22 and 24, it will be very clear to your Lordships that in the present matter, the appellants all received inherently defective products, to which the appellants had no fault of their own. Your Lordship, the Council would also like to put before this honourable bench clause 8 of this particular provision, which clearly states that it is an unfair trade practice whenever a seller refuses to withdraw or to take back such defective products. And if such seller also refuses to recompense the appropriate
Whether it was
refund.
a defective product or not, how one comes to a conclusion?
Indeed, Your Lordship. Your Lordship, may I please
Now
refer?
you can say that it was a defective product and therefore it was fine.
Indeed, Your Lordships. Your Lordships, the Council would like to answer your question in 2 points. Firstly, Your Lordships, it is not even disputed by the respondents in the present matter that the goods they received were defective. In fact, clause 4A is also applicable on defective products, meaning thereby that the e-commerce platform is also refusing to take responsibility for defective products that they themselves gave to the appellants in the present matter. In fact, they will be arguing on the very validity of that particular clause. This is clause number 4A, Your Lordships. Your Lordships, secondly, on paragraph number 11, it is clearly stated that one appellant in the present matter, since this is a class action suit, Vijay Kumar, Mr. Vijay Kumar, he ordered a laptop from the e-commerce website's platform. The laptop was delivered to his residence 2 days later, and after using the laptop for a few days, Vijay noticed it frequently overheated and the screen flickered intermittently. Your Lordship, despite raising this particular plea in front of the e-commerce platform's consumer redressal, the consumer helpline also told them that even if this is a defective product, we will not be dealing with this. Your Lordships, pertinently, also on paragraph number 22, another appellant in the present matter, Ms. Renu Sharma, found that the product was defective and her return request was similarly denied based on the very same clause, which is 4A in question. The third appellant in the present matter, which is Anil Mehta, he purchased a smartphone during a festive sale. When the phone was delivered, it was found to be an older model and which was originally advertised. Does this answer your Lordship's question? Much of the Lordship.
Two quarters.
Indeed, Your Lordship.
Number one, it is an arbitration clause in the agreement.
Your Lordship, can I please beg you to repeat your question?
Whether there was an arbitration clause in the agreement.
Indeed, Your Lordship, there was an arbitration.
Now, if there was an arbitration clause in the agreement, whether the suit was mechanical because you had an alternative way, you had a remedy by going to the arbitration. This is number one. Second project being that you remove the clause of the agreement and then you click the button in the agreement. So can you say that this clause 4A was not known to me or no consent was taken? Will it amount to consent when you click the button there? These are the points.
Indeed, Your Lordship. Your Lordship, as far as Your Lordship's first question is concerned, the Council seeks for a movement of intelligence, Your Lordship. Your Lordship, I seem to have missed your very first question. On the arbitration agreement, much of Your Lordship, I'm very much. Yes.
That when there is an arbitration
Indeed, Your
clause,
Lordship.
whether you are binding upon you or not,
Indeed, Your Lordship.
to avail that remedy.
Your Lordship.
Answer on that to satisfy.
Indeed, Your Lordship. Your Lordship, agreed that there was an arbitration clause in this particular contract. Whether Your Lordship, arbitration is an alternate form of dispute remediation. Your Lordship, it is also a sort of a private sort of a remediation. And in the present matter, multiple litigants filed a class action suit sincerely and severely in front of the Mumbai High Court because it concerned the patent infringement of such consumer rights. Your Lordships, a consumer agreed has many remedies. In the present matter, the consumers also went to the district consumer forum. And Your Lordship,
Well, counsel, best answer would have been that this was never raised by the respondents, and if it all raised by the respondents, court never answered anything, or court was fully satisfied that even if there is an arbitration clause, it is not binding upon the courts.
absolutely.
It is not.
Indeed, Your Lordships, indeed.
Yes.
Your Lordships, and admittedly that consumers have appropriate many remedies in any matter. However, Your Lordship, it is the consumer is a small person. They are an average person. It is the common man of the country, Your Lordships. And the rights to approach a particular forum should be left to the election of the consumer, should be left at the option of the consumer. And this has also been held in multiple judgments. For example, Your Lordship,
So the
in
best
the
argument should come from the one you have.
Indeed, Your Lordship, indeed. Your Lordship, the very second question that Your Lordship raised, which actually brings me to the very first prong of my argument on issue number 1, that if in the present matter the appellants peruse the very agreement and their consent was given by the click of a particular button, then how can they say that there was no consent in the first place? Your Lordship, the very shortest summarized answer that the counsel can give you is that in the present matter, the appellants were never given an opportunity to peruse through the agreement concerned. Your Lordship, it is very important in standard forms of contract that consumers are given a genuine and fair opportunity to inspect all the terms and conditions of this contract. And the counsel should also be substantiating this in a later argument that by the use of dark patterns, Your Lordship, the counsel begs an extension of 3 minutes to sum up their issues.
Therefore, I told you that voting will be your best argument.
Can the counsel beg for another 2-3 minutes to sum up their entire argument?
All right, 1.5 minutes.
Absolutely, Your Lordship. Thank you. Your Lordship's question actually leads me to issue number 2, through which the counsel has only one argument to make, and the respondents have used dark patterns. Your Lordships, the dark pattern guidelines were notified by the Ministry of Consumer Affairs in 2023. They have lawful force and they have binding authority over all the e-commerce platforms operating within the country. And in the present matter, dark patterns are such unethical business practices used on the internet through which any particular e-commerce platform prompts the consumer to take such actions that it originally did not intend to do by impairing consumer autonomy. These dark patterns actually incentivize not reading a contract, not going through the contract. And then e-commerce platforms later enjoy the defense of saying that we gave you a contract, there was a contract before you. However, Your Lordships, the consumers were never allowed a fair chance, a fair opportunity to go through this very contract. Your Lordships, in this slide, the counsel would like to highlight 3 particular dark patterns. Firstly, Your Lordships, the dark pattern of false sense of urgency. All the appellants in the present matter purchase these pertinent defective products in a flash sale. In a flash sale, the respondents deliberately give maximum number of discounts and they place it under a limited time period that you have 8 hours to purchase this particular product, else it will go away and all the maximum discounts that we are offering on this product will immediately go away. Your Lordship, this creates an induced artificial sense of urgency in the mind of any consumer and they under pressure overlook the reading of the terms and contracts. Your Lordship, the second important thing in this case is that the entire contract was never displayed to the consumers. In fact, they were deliberately hidden behind a hyperlink. Your Lordship, even if the appellants had opened a hyperlink and even if they would have to go through the contract went on to 20 pages, all right with legalese. And the clause in question was buried on its 16th page. Your Lordship, these are all other dark patterns, the dark patterns of interface interference and the dark pattern of trick question. This entire 20-page document, even if the appellants found themselves on page number 16 of this document to find the very contentious clause, they would still have not been able to decipher or infer the legal consequences from such a document which is such rife with legalese. Your Lordship, this concludes the Council's arguments on issue number 2. The Council will only take 30 seconds to wrap up issue number 3. With the legal this honorable bench, may the Council please proceed to issue number 3? Absolutely, Your Lordship. Your Lordship, on issue number 3, the Council will be arguing on the question of whether appellants in the present matter can plead ignorance to the terms and conditions of this particular contract. To this particular submission, the Council has only two statements to make. Firstly, Your Lordship, the very fact that this is a standard form of contract in which sellers had a duty to make it known to the consumers all the terms and conditions, especially such terms and conditions which were very pertinent to the transaction. The term of non-returnability of all products, all defective products also, Your Lordships. This needed to be brought to the disclosure, the full and complete accurate disclosure of the consumers. And Your Lordships, since, as earlier demonstrated by the Council, this particular clause in itself is illegal and is a derogation on the Consumer Protection Act and the e-commerce rules of 2023, the dark pattern guidelines of 2023. Therefore, a valid plea of ignorance rests on part of the appellants in the present matter. If Your Lordships have any questions, the Council will be more than happy to answer them right now. Indeed, Your Lordship, you are.
You refer to unfair trade practice.
Indeed, Your Lordship.
Yet you never mentioned whether these particular article perform to the specification indicated in the website or it underperform the specification. So how do you justify that it falls under unfair trade practice?
Your Lordship, this is also Your Lordship's question in an earlier question, Your Lordship. In the present matter, firstly, Your Lordship, 2 points the Council will be making. The first point is that in the present matter, the respondents are not even disputing the fact that this particular item is defective. In fact, they intend to defend this particular clause by saying that even if a product is defective, we will still be not enforcing any returns, any refund, any exchange, or even any defective product. Your Lordship, as the Council went through all the appellants' grievances through the Moot proposition, it is very clear that in the present matter, the products that they were supposed to receive, the respondents in the present matter.
All right, satisfied. Best answer would have been it is the respondent very busy.
Indeed, Your Lordship. Indeed. Much obliged, Your Lordship. I will now be giving the rights to my co-counsel, Your Lordship. It was a pleasure arguing before you.
The Council seeks the permission to push matters.
Am I audible, Your Lordship? Greetings to the members of this esteemed bench. May it please the Honorable Court, I appear as a speaker number 2 on the behalf of the appellants in the present dispute between Vijay Kumar and others versus E-Commerce Corporation Private Limited.
What?
Speaker number 2, from side of appellants, Ila Singh.
Ila Singh.
Ila Singh. Your Lordship, my learning co-counsel has already deliberated upon issue number 1, 2, and 3, and with the leave of this court, I shall now proceed to deal with issue number 4 and 5 for the next 8 minutes. Much obliged, Lordships. Under issue 4, the Council contends that the clause restricting returns and refunds in the very alleged contract is indeed unconscionable in nature, and that the same is very violating of the consensus ad idem as mandated under the Indian Contracts Act. Your Lordship, my co-counsel has already delivered arguments on the aspect of consent. That is why, for the brevity of this court, the Council seeks the permission to limit its argument on the unconscionability aspect. Much obliged, Lordship. Proceeding with the Council's argument on unconscionability, Your Lordship, the Council has 2 brief submissions to make. Firstly, that the clause, which is clause 4A and clause 4C, explicitly is unconscionable in nature per Indian Contract Act. And second submission is that the present contract, the present exclusion clause is indeed disproportionate to the relevant other laws. Under my first submission, the Council contends that the clause 4A, which limits returns on the part of the respondents, and clause 4C, which limits refunds explicitly on the part of the respondents, is indeed unconscionable. In order for the bench to refer to the definition of unconscionability, the Council would request the bench to please refer to annexure flag number 24. Your Lordship, that particular page mentions the case of Central Inland Water Transport Corporation versus Brojanath Damli. If the benches would be on the same page, much obliged, Lordship. The very case, and if I shall quote from it exactly, it mentions the definition of unconscionability in the highlighted part. And if I shall quote exactly from the same annexure, it states, showing no regard for conscience, irreconcilable with what is right or reasonable, and unconscionable bargain would therefore be the one which is irreconcilable with what is right or reasonable. Your Lordship, the Council in the present case is not contesting the nature of the contract, which is a standard form contract, or the fact that the contract was formed by electronic media. The only thing that the Council is disputing is the nature of one specific clause, which restricts returns and refunds. Your Lordship, this very clause, even though the entire contract might not seem illegal per se, this clause is violating Consumer Protection Act. The Council would be delivering arguments on the violation of Consumer Protection Act under Issue 5. For the brevity of this court, the Council proceeds to argue under Issue 2 that the very clause goes against the nature of this present contract. An e-commerce platform which offers products under purchase agreement has a motive to satisfy the consumers. And the maximum or the most remedified way of doing it to deliver good products, and in case any consumer is having any grievance, then to offer return, refund or replacement for the same. However, this deliberate debar on their part in the entire contract goes against the very essence of having a consumer contract. Secondly, the Council would like to take you to memorial page number 27. If the bench is with me on the same part, memorial, Your Lordship.
Yes.
On the topmost part of page 27, it is explicitly written that Halsbury law of England, which is a common law jurisprudence commentary, Your Lordship, and since India is also a common law country, the same would fall within the jurisdiction of our laws. Halsbury law of England reinforces that a stipulation in a policy may be so capricious or unreasonable as to be unenforceable as a fundamental term of the contract. Your Lordship, this is exactly the submission of the Council in this issue, that the term restricting returns and refunds, specifically clause 4A and clause 4C, are capricious and unreasonable. With this, the Council seeks the permission to proceed with issue number 5. Much obliged, Lordship. Under issue 5, the Council contends that the e-commerce platforms indeed have obligation in ensuring that the consumers are fully informed of the terms and conditions, and secondly, that the failure to do so indeed amounts to violation of the consumer rights. The Council proposes to address this very issue in 3 main submissions. Firstly, that there has been a violation of Consumer Protection Act. Secondly, that informed disclosure is indeed a legal mandate. And thirdly, that there has been a violation of the reasonable communicativeness test. Under my first submission, the Council contends that Your Lordship, Section 23 of the Indian Contract Act determines legality and consideration of a valid contract. And if I shall quote exactly the same lines from the very set thereat, it states, consideration or object of an agreement is lawful unless it is of such a nature that if permitted, it would defeat the provisions of any law. Your Lordship, any contract, any valid contract cannot defeat the purpose of any other existing law. With this pretext, the Council would like to proceed with the submissions of Consumer Protection Act. Your Lordship, Section 2, subsection 9 of Consumer Protection Act lists down certain consumer rights. The major point that the Council is trying to highlight from those consumer rights is one clause which mentions, and I shall quote exactly, the right to seek redressal against unfair trade practice or restrictive trade practice or exploitation of consumers, etc. Your Lordship, right to seek redressal is right of a consumer as enlisted under the Consumer Protection Act. I would request the bench to please refer to Annexure E that the Council has provided with the blue flag. Annexure E.
We proceed.
Yes, Your Lordship, much obliged. The said annexure, it must be in pages, Your Lordship.
Yes.
E, annexure E. Your Lordship, annexure E is a screenshot of a National Consumer Helpline Forum, which is administered by Ministry of Consumer Affairs and it's a legal authority. The very said website of National Consumer Protection Helpline lists down grievance redresses for a consumer, out of which the Council has highlighted 2 to 3 grievance redresses, which is return, refund, or replacement. Therefore, these are legally recognized grievance redresses mechanism. However, as per clause 2.9, when the respondent is not providing rights and returns and refunds on the very said products, they are derogating section 2.9 of the Consumer Protection Act. With this, the Council seeks permission to proceed to the second submission. Much obliged, Your Lordship. Under the second submission, the Council states that informed disclosure is indeed a legal mandate. Your Lordship, the very said section 292 of the Consumer Protection Act, and if I shall quote exactly from it, it states, a consumer has a right to be informed about the quality, quantity, etc., and the services offered as the case may be. In the present case, the respondents were duty bound to inform the consumers about any services available or quality or quantity of the product. However, a critical clause is that of return and refund was buried on the 16th page of the very said contract. In order to further substantiate on the same, the Council would request the bench to please refer to annexures C and D. The same pages. Your Lordship, annexures C and D are screenshots of 2 very prominent e-market practice, which is Amazon and Flipkart. If you may please refer to the highlighted part, it is explicitly inferred from the very said annexure that they have deployed all the critical clauses like that of return, refund, even the details of the product in one concise page. Instead of having it on a 20-page long document, wherein a critical clause as that of return and refund, which might alter a consumer's decision of whether buying that product or not, was deliberately buried on 16th page. And as already deliberated for my co-counsel, the respondents have also used dark patterns so that even though the contract is available, the consumer might not go through it because of availing other benefits by not going through it. With this, the Council proceeds to the third limb of my argument at issue 5. Much obliged. The Council contends that Rule 5 of the e-commerce rule states that the consumer should be provided with information in a clear and accessible manner, which means that it gives birth to a principle of reasonable communicativeness test, Your Lordship. Which means that the terms and conditions which might be very critical to the conscience of the consumer should be reasonably disclosed to the consumers. However, as already deliberated, these terms were given behind a hyperlink, which even though the Council contends could have been opened by the consumers. However, by providing flash sales, by deliberately designing hyperlinks, a consumer is incentivized to not open it and go for the flash sale and purchase button. With this, the Council would like to make the last submission of issue 5, which goes on to state in arguendo that in the present case, even if the bench agrees that the respondent is an intermediary also owes certain duty to inform it. The Council seeks an extension of 1 day to wrap up this argument and the prayer. Much obliged, Lordship. Your Lordship, even as an intermediary which provides or facilitates transaction between sellers and consumers, they are duty bound to disclose what seller is selling what. For example, the website of Amazon shows that this product has been sold to us by this party. In the present case, respondents nowhere in their annexures or nowhere in their contract have mentioned that they have received product from third-party sellers or even mentioned those third-party sellers, which goes against the principle of Rule 5. Rule 5, and if I shall quote exactly from the said rule, it states that every e-commerce marketplace entity should disclose details about sellers who are offering goods on their website. Pertinently, the second rule, which is Rule 6, Sub-Rule 5, mentions that any seller offering such goods on their platform should display all contractual information required to be disclosed by law, which means that the respondents were also duty bound to disclose any contract that they might have had with sellers, which was not the case in the present dispute. With this, the Council rests its submissions and seeks the Commission to proceed with the prayer. If the bench has any questions on the submissions, the Council will be more than happy to answer them.
One question.
Yes, Your Lordship.
There is a proposition of buyer beware,
Yes, Your Lordship.
and then you are also advancing your argument on the unfair trade practices. How do you balance both things?
Your Lordship, the buyer beware is a contractual principle that the entire foreign present here must be aware of. However, the principle is not absolute in nature because standard form contracts hold a special place in the field of contract. Standard form contracts, especially e-commerce standard form contracts, are of such nature wherein consumers do not usually go to the terms and conditions. Specifically, when the consumer is a layman, they might not go through those terms and conditions and end up not reading them. However, the entire jurisprudence on standard form contracts have ended up providing remedy to the consumers, even when they might not have gone through the terms and conditions, and specifically when the terms were inconspicuous or unconscionable, pursuant to the rights of the consumer. The consent merely by clicking I agree does not mean that the consent was voluntary. It was specifically engineered by the design patterns. If that satisfies the bench, much bench. The council proceeds to declare. Therefore, in the lights of facts stated, arguments advanced, or authorities cited, may this honorable court be pleased to hold and declare that the e-contracts in the present case was unfair, illegal, and unenforceable. Secondly, that the same amounts to unfair trade practice. Thirdly, that ignorance can be claimed, specifically when the terms are illegal per se. Fourthly, that the terms restricting returns and refunds is unconscionable and violative of free consent. And lastly, that the respondents are duty bound to inform their consumers of all the terms and conditions, and that the same failure to do so, the same amounts to violation of the Consumer Act. With this, the council rests all of its submission, and it was a pleasure arguing with the bench. Thank you, Lordships.
Regardless of who was the respondent on that.
Greetings to the bench. The council would like to seek permission to address the bench of your honors. Much obliged, Your Honor.
Use yourself.
Yes, I will be doing that. Thanks. So, I am Speaker 1, appearing on behalf of the respondent in the case of Mr. Vijay Kumar, Petitioner versus E-Commerce Corp Private Limited, Respondent. I will be presenting first, I will be dealing with first, second, and fifth issue, and my co-counsel, which is Speaker number 2, would be dealing with third and fourth issue. The time division would be 15 minutes for the Speaker 1 and 10 minutes for the 20 minutes for Speaker 1 and 10 minutes for Speaker 2. That will be the time division. If your honors are satisfied, the council would like to proceed.
Yes, proceed.
Much obliged. If your honors are satisfied with the statement of facts and jurisdiction of the case, the council would like to proceed with the first issue. Much obliged, Your Honor. India, which is pari-matry to Hindustan, which is pari-matry to India, its e-commerce market depends on three things: speed, simplicity, and minimal transactional friction. India is one of the fastest growing e-commerce platforms in the e-commerce markets globally, and the market has expanded from $39 billion in 2017 to around $120 billion in 2020, reflecting an annual growth rate of around 51%, which is commendable, the highest recorded internationally during this period that I have cited. E-commerce and goods alone has witnessed around 57% compound annual growth rate over 7 years and was projected to continue growing at 18.6% per annum until 2022. Such scale is possible only because the purchasing process is frictionless and efficient. And thus, we would like to make the point that e-contracts play a major role in actually facilitating this entire transaction between all that is taking place on e-commerce platforms, and the reason why it's seamless is standard form of contract only. Now, I'll be dealing with the first issue, which is whether the e-contracts formed through e-commerce platforms, particularly those agreed upon through the express purchase feature, are valid and enforceable. It is humbly submitted that e-contracts concluded through express feature are valid and very much enforceable. Section 10 of the Indian Contract Act lays out the essentials of a valid contract, and if those if those essentials are fulfilled, a contract is a valid contract. And Section 10A of the IT Act 2000
recognizes such valid contracts in the form of electronic contracts, e-contracts to also be valid. The UN-central model law on electronic commerce has clearly stated that e-contracts can be made by exchanging data messages, and when the data message is used in the formation of a contract, the validity of such contract should not be denied. So even UN has mandated the validity of e-contracts. So it is nowhere unenforceable and invalid. I would like to take your honors through through each essential of a valid contract, and I would like to provide as a valid contract in the first place. So there was an offer, there was display of goods online for the consumer, there were prices mentioned, everything was available on the screen. Also, as the opposing counsel mentioned that the manufacturer's details were not mentioned, but it is just a mere presumption because nowhere in the facts is mentioned that we did not provide with the vital information to the buyer. The origin of any product is mentioned on the very page or the very first place when you take a look at the products that are displayed for sale. So the manufacturer has already mentioned it. So that information was clearly disclosed and was a presumption from their side. Second is acceptance. The consumer's act of clicking express purchase or I agree amounts to clear acceptance. Here it has been consistently pointed out by the opposing counsel that there was no free consent or no acceptance by the consumer. But we cannot deny the fact that the hyperlink, which consisted view terms and conditions, was clearly and conspicuously placed right next to the buy now option. So any consumer who had to proceed with the transaction seamlessly had to click on buy now option to be able to make the payment. And if they are clicking on that button to be able to proceed with that, first they had to click on I agree button, which is given in the hyperlink itself. So when you're clicking on I agree button to be able to proceed further to make the payment, which happened in this case, you have had to take a look at the terms and conditions. You would have had to gone to the utmost last point of the entire contract, and then only you would have clicked on I agree button and moved ahead with the transaction. So here the consumer was given enough chance and opportunity to skim through all the terms and conditions, and it was consumer who chose not to go through that, given the fact that he chose to be grossly negligent and is now claiming an injury which would have easily been avoided had he exercised his reasonable knowledge and a little bit of prudence that a reasonable consumer would have. So that is the case. If we talk about consideration, the payment made by consumer constitutes consideration a valid and lawful consideration in this case. And the service that is provided by the service provider, which is the e-commerce. Yes, sir.
You said you have terms and conditions. But then it was the mandatory requirement to go through the terms and conditions before buying the products.
Your Honor, it's not mandatory, but then as you mentioned, buyer beware. Whenever you're signing any contract, there is a maximum of caveat signature, if I'm not wrong, caveat subscriptor. You beware of what you're signing on. And then if you have signed on anything, knowing that you're signing and entering into legally binding contract, which if I'm allowed, I would like to draw your attention to.
Only because they have their signature, their heads are cut. They will no more raise any dispute.
No, Your Honor, that is not what we contend. Please take a look at Annexure A of the Moot proposition on page number 7. Are you honest with me?
Yes.
Yes. The third line, the very first paragraph of the Annexure A third line reads, by clicking the I agree button or checkbox during the purchase process, you accept these terms and conditions in full. Yes, sir. Yes. It's the page number 7 of entire Moot problem that is being provided. It reads Annexure A. Yes, Your Honor, Moot problem. You need to refer to the Moot problem. Okay, I'll go ahead with that. So by clicking on I agree button, you accept these terms terms and conditions in full. First of all, you do not agree with any part of these terms, you should not proceed with the purchase. It clearly mentions here at the very beginning itself. You don't even need to go to the 16th page and read 4A to be able to make sure that you will be legally bound by these contract terms that you have agreed to. Also, definition clause D, which talks about manufacturer's warranty. The warranty offered by original manufacturer of the product purchase is what is meant by manufacturer's warranty. So we are indeed providing them with an remedy, which is a warranty. We will be providing them with repair services, and we are ready to comply with whatever issues that is arising with the goods we have sold. But we do not give a guarantee of the product. So they cannot claim something that we are not even giving them. And it's clearly mentioned on the very first page of the measure. Also, acceptance of the term, which is clause 2. It mentions that by using the express purchase feature, again, it is a feature that you choose on your own accord. Not every consumer has to choose this feature. Just because you want to save time, you can choose this feature and it will make your transaction process much more seamless and easier. So the consumer has willingly chosen this first of all.
Your client is dealing with the consumers.
Yes, alright.
There is a, your client must be aware of the consumer. It's a parliamentary. The whole purpose of this law, was the quality product should go to the consumer.
Indeed.
Number one. Number two, action be provided in case of defective product and deficiency in service. If that be so, whether your clause 4 is against the parliamentary law.
Indeed, Your Honor, I very much agree to what you said. That is the intention of Consumer Protection Act to ensure the welfare of the consumer. But as you mentioned, quality products should be sold to the consumer. And here the e-commerce platform is an intermediary first of all. We provide you with a platform to interact with the seller, and we bring both the seller and buyer at the same place so they can interact together, agree to the goods that they want to buy and sell with each other, and enter into a transaction. And we provide the delivery of the goods to the rightful person, and also in case of any return, we provide that service as well. So here, what?
Sorry,
Indeed.
very well. You are delivering product or even somebody else. Is it not your duty that the quality product should go to the consumer?
Your Honor, we have certain standards through which every product goes through, and only then we provide those services. And hence you can see that there have been 3 cases out of so many transactions that take place over a span of time. As I already mentioned, the number of transactions that take place on e-commerce platforms every day, it's humongous. It's not even in thousands and lakhs, I would say it's in millions, more than 10 lakh transactions a day. So keeping a tab on each and every transaction that is taking place is not only, it's not possible, it's manually not possible, but we are providing with in case there is...
Both are there. The producer and the consumer at one product. And what I get, both produce the somebody else. Now, in that case, since both of them are in one product, it is not possible that a defect product is given to the consumer. It should be returned, it should be replaced by
Very rightly pointed by Your Honor. And for that, I would like to point something of utmost importance to the notice of law. What has been happening over the period of time, and what we as well as the manufacturer, as a result of which has been facing, is return fraud. It has become a major challenge in the entire e-commerce industry. It involves intentional misuse of return systems to obtain wrongful gains, such as returning used, damaged, or counterfeit products in fact, or swapping valuable internal parts of components before sending items back. You know, Your Honor, that electronic products constitute some very valuable materials that we use. That also consist of rare earth minerals, whose supply is very much in shortage, and it's hard to acquire. So whenever we sell an electronic product, it costs a lot more than actually it's being sold for. But what consumers are doing these days, and I have empirical data to prove my point, that nearly 10% of all the products returned in Hindustan, which is carry magic to India, it may be fraudulent, and I'm talking about 10% of the entire transaction, leading to aggregate losses in the thousands of crores. Take for instance Myntra's case. It reported a fraudulent return scam causing losses of nearly 50 crores. Industry-wide studies show that electronic goods are the category most frequently associated with return fraud, and that is why in the next also you will see, Your Honor, that in clause 5 we clearly mention that we are not disagreeing to return all products, but just electronic products in the category of entire product range. Because it is more susceptible to fraud.
That quality product what is talking about not excuse.
No, no, that is
You
not.
say that the grievances will be redressed, what will be
Yes, Your Honor, we cannot overstep what we.
Before you answer, I just add, does this act make any distinction between electronic products and non-electronic products? Number two, you are given a service to consumer. Is it not a deficiency service negative clause?
Your Honor, I would like to answer the second question first and then the first part. As you talked about deficiency of service, Your Honor, we are a delivery service. So, our deficiency in service would be that we are not delivering the product on time. We are delivering a damaged product. We are delivering any product which was not ordered for. We are ready to accept that there was deficiency of service. But for the products that have been rightly delivered, well on time, if you are having any issues, that needs to be dealt within the ambit of our standard contract like clauses that we have mentioned, and that is what we are doing. Since it's a manufacturer warranty that needs to be provided in electronic goods, we are providing you with that. We are providing with repair services also. So that is not something that we can take into consideration, and it has not been a deficiency of service on our part as a service provider. If your honors are satisfied, I would like to go ahead.
proceed further.
Much obliged, Your Honor.
Right.
Again, breaking. It's a common form of return manipulation in electronics. It's where purchasers dismantle the product, extract valuable parts, and then return the device for a full refund. The extracted components are later resold at profits. According to 2020 Global E-commerce Fraud Report released by Rahul Limited, electronics experienced return fraud rates between 12% to 18%, which is huge. The highest among all product categories. Further, in 2023, Amazon, which is one of the biggest e-commerce platforms in the country, it reported approximately $6.3 billion worth of returns classified as fraudulent, with small electronics forming the majority of such cases, Your Honor. This has been a consistent trade practice, and because of that, we had to come up with a solution that is not detrimental to the consumer, but also not loss-making for the seller as well as the service provider. Because we also have to bear reverse logistic cost. Because whenever a product is returned, it's a complex process. We have to trace back the manufacturer, then we have to get a new product, and it takes a lot of time, plus reverse logistic cost. And by making refund, it's not the consumer who's bearing the cost of refund, it's the service provider itself. So since we have seen a pattern in this particular category, that is why we have tried to ensure that we come up with a clause that kind of protects both the parties and is not leaning towards benefiting one or either. A neutral clause, basically. Therefore, the non-returnability clause is not intended to deny genuine consumer remedies. It is a proportionate and commercially necessary safeguard designed to first prevent systematic abuse of return system, protect product integrity, because also when there is a return of product, a lot of times, as I mentioned, that consumers misplace some components of it and return it, and then it is delivered back to some other person who might have placed an order. Because we are not able to see what is inside the product. We buy it as a new and brand new product from the manufacturer and we deliver it to the seller. But then once the seller has refunded it, we don't know what the seller has done with it. Although we do have a checking requirement, but it is hard to detect at the first instance that the product has been returned intact. Unless we go through the technical checking or the process to check if the product is intact. By that time, it's already in transit and it's very hard to return it back to the consumer. So then that loss is on us. So that is there. We also want to maintain fair pricing for all consumers and ensure sustainability of e-commerce operations. Enforceability of standard terms in e-contracts. So the principle regarding enforceability of online standard form contracts was affirmed in Pro CD versus Edinburgh case, where the court held that a contract is formed only when the user, after having a reasonable opportunity to review the terms, clicks I agree. Online terms, if visible and reviewable before acceptance, they constitute adequate notice. And acceptance constitute binding assent. And here we have given an adequate notice. In the nexus, it was mentioned that it's a binding contract. Through multiple clauses, before even reaching clause 4, it was mentioned that it will bind you in a legally binding contract. So that shows the gravity of the e-commerce contract that we have placed on a platform. And it was expected that a consumer would be a reasonable consumer and go through it and understand. And then choose for themselves. We did not choose for them. It's them who made the choice. Also, in contrast, on challenging standard form terms, so to challenge the validity of standard form clauses, the consumer must demonstrate absolute necessity of the good, leaving no real choice. That is not the case in this case. Unconscionability arising from oppressive or shocking inequality, no such circumstance exists here. Electronics are discretionary products. The consumer retains alternatives and clause serves a legitimate protective function only. Courts do not strike down standard terms simply because they are non-negotiable. The challenger must prove both absence of real choice and terms that are considered to be unconscionable both. Neither condition is present in the present scenario, and the clause here is industry standard, commercially rational, and publicly disclosed. If your honor is satisfied, the company would like to proceed to the fifth issue and would continue with the arguments. Much obliged. The fifth issue is whether e-commerce platforms have any obligation in ensuring that consumers are fully informed of the terms and conditions before agreeing to the same, and whether failure to do so would amount to a violation of consumer rights. Your Honor, the Council duly submits that we agree with the first part of the issue raised, that we do have an obligation to ensure that consumers are fully informed of the terms and clauses that we as a e-commerce platform have. But the second part of it, whether failure to do so amounts to violation of consumer rights, we do not agree with this. Because we did ensure that everything is published online, it is very much in view of the public domain, and the consumer has all the time and ability to skim through all of that and then decide for themselves. So we have not violated with any of the consumer rights. Also, Rule 5.3c of the Consumer Protection E-Commerce Rules 2020 require that every marketplace e-commerce entity must display in a clear and accessible manner essential information relating to return, refund, exchange, warranty, delivery, payment method, and grievance redressal so that consumers can make an informed purchase decision. In the present case, the platform clearly complied with all of these requirements. The non-return clause, along with other terms, was not hidden or obscured. A hyperlink titled View Terms and Conditions was placed directly adjacent to the buy now option, and that by clicking that only you could proceed with the payment transaction. So this is a prominent placement that provides the consumer with a real and meaningful opportunity to review the terms prior to the purchase. The law does not require the platform to individually explain or highlight each clause. It nowhere mentions this. The requirement is availability and clarity, not personalized disclosure, Your Honor. And in fact, we could have come up with certain alternatives to make the consumer more well aware, but where we are failing is, if we require multiple separate consent, it would disrupt the functioning of entire system. Scholars and regulatory analysts have proposed alternatives such as highlighting specific clauses in bold or in separate text boxes, or requiring separate I agree clicks for clauses perceived as sensitive. However, these models assume that consumer will meaningfully engage with the e-commerce platform. But in majority of the cases, it's the consumer who's not even willing to read the clauses citing that these are law, but it is for their welfare also. We have certain clauses that actually protect the consumer, but they don't want to engage. They don't want to read or actually spend the time despite having the ability to read, despite having the ability to understand. Because most of these clauses are in simple, understandable English that anyone with workable knowledge of English can understand. So that is why these would be a huge failure actually, even if we tend to implement these particular alternatives. And they would create transaction fatigue instead not awareness. Well, lastly, I would like to conclude by saying that obligation of the platform is reasonable disclosure, not guarantee of consumer attention. The law does not require the platform to ensure that the consumer actually reads and the terms. Otherwise, every consumer would escape their liability and responsibility simply by claiming that I did not read the clauses and hence I want the remedy. So with that, we rest the case, and if your honors have any questions, regarding the like to answer. And I would like to invite my co-counsel to deal with third and fourth issue. Thank you, Honor.
You do not cite any judgment in this point. Whether ignorance of law.
Your Honor?
You do not cite any judgment for this.
Of which ignorance of law.
What judgment first? Any authority on this to the court?
The fifth clause that I mentioned, the fifth issue. Your Honor, I have taken the authority of research paper published, but I have mentioned the place where I have taken this one because it's a US-based research paper. Since US has a more, I would say, first of all, it's the headquarters of most of the e-commerce companies that are operating even in countries like Hindustan and country to India. So I think that their jurisdiction and their jurisprudence is much more relevant to ours because that is where it's coming from. Most of the standard contracts are also coming from there itself.
Yes, gather strength, your point gather strength, the legal issues gather strength by citing any authority.
Indeed, Your Honor, I have cited
Each authority is cited.
for this particular issue that you're stating. For that, I have cited this research paper only because there. I'm assuming that you're asking reference to fifth issue only.
Correct, not very bad.
I'm much surprised.
Sorry, you are not.
No.
Not be discouraged.
No, I'm not.
The prior permission to the bench, if Constable would like to approach the bench, and the speaker too, I will be keeping with the issue number 3 and
Respondents. Yes.
in the digital environment, opening a link document is as simple as clicking a button, just as one would turn the page of a physical contract. Over the consumer choose to proceed after being given this easy and direct access, they are deemed to have a constructive notice. They cannot claim ignorance of term, they deliberately choose not to read. The issue number 3, third, deals with whether a party can claim ignorance of term in a contract, especially in electronic agreement, where user clicks I agree without reading the detailed terms and conditions. So the first submission is that the nature of the contract was used as a standard form of the contract, where it says that both in today, both online and offline are most are addition contracts. An addition contract is a standard contract, the content of which determined advance by one contracting party which decides on the condition under which the contract will be concluded and offers of the conclusion to the contract a larger number of the person. There are a lot of advantage of these type of contract. First, it lowers the cost. All the transactions of the same types are proceed in the same way. Bargaining about future contracts takes time, money, and so concluding addition contracts save both. It's a more standard term, have been tested in court, so that the parties, at least theoretically, save litigation expense as well. Also, addition contracts are more suited for mass consumer transactions. If the petitioner is willing to say that every liability will be imposed on the intermediary which provides services, it would become so disappropriately burdensome, making it difficult for them to operate, ultimately affecting the smooth functioning of the digital economy, as well as affecting the ecosystem. It would make compliance extremely costly and complex. It will discourage them to be the one who proceeding the service. And also it will reduce the consumer choice and increase the prices and slow down the digital economy. The click wrap agreement, that was the form of the agreement that the consumer used. Here the contract in the user will be much declared in a direct way. There was an explicit manifestation of assent to the term. Therefore, the user often, or at least should, be aware of their assent. Under the case of Brock versus America online, the court stated something very important. Here, the plaintiff effectively signed the agreement by clicking I agree. Under these circumstances, he should not be heard to complain that he did not see, read, etc. is bound by the terms of his agreement before a click was equalized with a signature in a physical word. As already noted from then on, court have largely imposed most click-wrap agreements. It's a general rule that a party who agrees to an instrument by clicking I agree cannot later claim that they did not read or understand its content. The court found that contract to be binding because the plaintiff had signed it by clicking I agree. Also, the counsel would like to draw your attention of the bench that the respondent had fully fulfilled the essential requirement of the click-wrap agreement, which is enforceable by under section 10 of the Indian Contract Act. By that, the notice of so we don't think it would be.
In this case, all the consumers are there.
Yeah. It hasn't been not mentioned yet.
It is not.
No. The counsel would like to further argue the court issue.
Yes,
Whether a clause restraining return and refund for electronic item under express feature is unquestionable violative of principle of free consent under Indian Contract Act. In the present case, the petitioner voluntarily engaged in the purchase process with full opportunity to review the terms prior to acceptance. There was no element of coercion, fraud, or undue influence affecting the consent. The respondent provided clear access to all terms through a hyperlink, complying the I agree checkbox, satisfying the requirement of informed consent under the law. Here, the contract satisfies all the essentials under section 10, which my co-counsel have already mentioned. And also the competence of the party under section 11. Every person who is an age of majority of sound mind is competent to party. The petitioner, being a registered user of the respondent e-commerce platform, was competent in law to enter into such transactions. Thus, contract formed between the parties are legally enforceable. Also, the section 10A of IP Act 2000, will give prior permission after that. The statutory provision clearly validates click-wrap and e-contract executed through electronic communication. It provides that a contract shall not be deemed unenforceable merely because all the communication of offer, acceptance, and revocation is made in electronic form by means of electronic form. Here, the respondent offered a good for sale through its e-commerce platform, thereby making a proposal in electronic form. The petitioner accepted the said offer by selecting buy now option, affirmatively clicking I agree checkbox, thereby communicating acceptance electronic. This exchange of offer and acceptance fulfill the essential requirement competent by under section 10A, rendering the contract valid and binding. Also, the section 10A is an adequate electronic contract with traditional written contract, thereby promoting certainty in online commercial transactions. Courts in India have consistently recognized the enforceability of click-wrap agreement when consent is expressly indicated through affirmative action, such as clicking I agree. Accordingly, the contract between petitioner and respondent cannot be invalidated merely due to its effectively mode of execution. The cornerstone of a legal enforceable contract is free consent or consensus ad ideum, a meeting of mind. If one party considering a material fact or term, it undermines the meeting of mind, potentially rendering the contract to be void. In the present case, the respondent has fully complied with its disclosure obligation. Every inventory e-commerce platform is required to provide accurate information regarding returns, refund, exchanges, warranties, delivery, shipping costs, payment modes, and devices and redressal. All the legally mandated notice, including the ability to track complaints. The petitioner, by explicitly agreeing to the terms and conditions and completing the purchase process, has acknowledged the accepted all such terms, including the non-refund clause, as the clause was clearly disclosed and petitioner had genuinely opportunity to review and consented to it. The contract cannot be invalidated merely because it includes non-refund provision. Thus, the respondent submit that the non-refund clause is valid, lawful, and enforceable, and does not vitiate the contract for lack of free consent. With your prior permission, the counsel will be discussed. In the view of facts and circumstances and legal submission made therein, it is most respectfully prayed that this honorable court may please to dismiss the present petition complaint as being devoid of merit and based on incorrect interpretation of contractual rights and statutory provisions, uphold the validity and enforceability of the excess purchase returns, including the return, refund, and restriction as a lawful contractual clause entered into the free consent under Section 10(13) of Indian Contract Act. Try to continue. Both the imputed clause does not constitute an unfair trade practices nor violate the Consumer Protection Act 2019 and or the Consumer Protection E-Commerce Rule 2020 as the term was duly disclosed, consented and to based on industry standard for electronic goods. Both the petitioner having knowingly consented to the term is stopped from the challenging them and dismiss the claim for refund, damage and compensation and award litigation costs to respondent for the frivolous and unsustainable proceeding instituted by the petitioner and pass such orders that are deemed to be just and proper.
Does the petitioner wish to offer any rebuttal?
The Commission proceeds with the rebuttals. Your Lordships, proceeding with my rebuttal, the Council briefly would like to state before this honourable bench that the respondents at times and times have tried to mislead the court by providing uninformed information. The Council would go on to state 6 brief points for its rebuttals. Firstly, that the respondents have argued 2 points beyond their memorial submissions, which is not even explicitly mentioned in their written arguments. Firstly, their argument of intermediary, that they are mere intermediary, is nowhere to be found in their memorials. Notably, the Council would like to dispute the very fact in their rebuttals that they are not an intermediary, because e-commerce rules mentions 2 kinds of e-commerce entities. Firstly, inventory e-commerce entity. Secondly, marketplace e-commerce entity. Your Lordship, the Council have contended that they are taking product from third-party sellers and making it available to the consumers. However, in the present contract, if you may please refer to page 8 of the Moot proposition, it explicitly states that the contract is between a consumer and an e-commerce corporation and not a third-party seller. Lordship, even if there was a third-party seller involved in the present case, the respondent was under the obligation to disclose the same in the clauses, which is Annexure A, and these clauses are nowhere to be found. Secondly, under the marketplace e-commerce entity, it is written that it means the e-commerce entity which provides an information technology platform. If they were a mere information technology platform, which is just providing a platform to facilitate, the contract would not have been binding just to them, but also to the third-party providers. Proceeding with the second point, they have stated certain facts and statistics regarding losses that they were facing because of returns. For example, they have used the phrases 50 crores, they have used Mintra and Mintra losses. However, it is not legal before this bench to use such terms to state that they are also facing the same kind of losses. Particularly when those clauses and those laws arise from the internet and not from the fact sheet. Proceeding with my second rebuttal, the Council contends that the respondent has said that the consumers could have raised their fees before the product manufacturer, which is through the warranty claim. However, Your Lordship, the warranty claim clause specifically states that the product manufacturer could only provide repairs and replacements, no returns or refunds, which is the grievance of the consumers. And they have willfully absolved themselves of this very liability. Proceeding with my third rebuttal, the Council contends that the present, they have cited a research paper for the authority. However, Your Lordship, it is very apparent to know that research papers are mere opinion of few scholars. They cannot have a binding or even a persuasive value before this bench. Proceeding with my next rebuttal, the Council submits that the opposite party have times and again used the phrase 3 applicants or even a consumer, the Council seeks extension of 10 seconds, or even a consumer who was 35 years of old age. However, that very contract is available to all the consumers at large, and it was a class action wherein multiple other consumers went on. It was a pleasure having you before the bench.
The Council
also would like to rebut the warranty claim point that opposing counsel had raised about repair and replacement. So, as you already mentioned, that it was under warranty of the seller, and the actual grievance of the opposing counsel was replacement and not repair and refund. Repair and replacement. No, they wanted refund and not repair and replacement. So why did they not make the seller the party to the suit and instead the intermediary? Because we have clearly mentioned that we would be providing the repair services and not the refund service. So it was actually, I would say, an oversight on the part of the opposing counsel for not choosing the right defendant in the case. Also talking about the class action suit, so the grievances that have been raised in the suit together, they are, first of all, there are three major issues that have been raised, three major people who have raised their issues, and it is related to, again, the same clause 4A, return clause that has been mentioned. But to us, it does not appear to be an issue of public policy. Because a public policy would be something that affects public at large. This is the issue faced by some of the consumers who have had this issue, and also one of the consumers who has become a party to this class action suit, Mr. Amit Kumar. His grievance is actually related to delivery of the wrong product, so he should have kindly come to us and placed his grievance with us, and we could have actually been able to provide him with a solution, and instead he chose to go for the class action suit and not the alternative remedy that is already available to sort it out with us. So his grievance is also not even liable to be considered under class action suit. So these are the two rebuttals that we would like to offer. Thank you.
Session answered.
Ranchi.